Right, so let's start. So welcome everybody, dear friends of the Center for Access to Justice and Inclusion at Anglia Ruskin University. This is another in our series of research webinars. And today I'd like to welcome especially members of the center, including our doctoral student members and advisory committee members, and indeed all students who are participating today. In today's session, we have the pleasure of hosting Judge Thomas S. Wood, who will be speaking about lessons on access to justice and inclusion from the Provincial Court of British Columbia. Tom was a member of the bench of the Provincial Court of British Columbia from 2007 to 2019. His appointment came after a 20-year career as a barrister, and before that a 10-year career in psychology. While sitting, he heard cases in the court's adult criminal, youth criminal, family, child protection, and civil divisions. Tom's practical and academic interests in law cover a very wide spectrum. He has authored numerous articles and book chapters on expert evidence, electronic evidence, defamation, ADR, and many other areas. He has also co-edited and contributed chapters to expert evidence in British Columbia Civil Proceedings, the British Columbia Civil Trial Handbook, and the Provincial Court Small Claims Handbook. And since his retirement, he has kept busy, if not busier. He has remained active in legal circles. He continues to contribute to scholarly legal literature and serves as editor-in-chief of the Commonwealth Judicial Journal, where in fact Tom and I crossed paths and worked for a while. And in January, he was appointed a trustee of the Ottawa-based Canadian Foundation for Legal Research. Before we begin with the presentation, could I please ask you to turn your mics off, and that is simply not to cause interference. And I would also note that this session is being recorded and will be made available online. And in terms of the structure of today's webinar, there will be a time for questions after Tom's presentation. However, you can also use the chat function in Zoom to write any questions you may have. So without much further ado, Tom, the floor is yours.
Thank you, Aldo. It's lovely to be back in touch with you. Other members of the group today may not be aware that I succeeded Aldo as the editor of the Commonwealth Judicial Journal, and Aldo and I became good friends and colleagues in that process. And it's a pleasure to be back in touch, and it's a pleasure to be participating in this webinar, originating in Cambridge, England, which is certainly one of my very favorite English cities. And I thank you, Aldo, for that generous introduction. I'm going to start by putting the Provincial Court of British Columbia, where I sat as a judge until last September, on the map, just so you know where it fits into the broader context of the court system in British Columbia and Canada. The Provincial Court is a trial court, one of two trial courts in the province of British Columbia. The other is the Supreme Court of British Columbia. And the Provincial Court and the Supreme Court of British Columbia have substantial overlapping jurisdiction in various areas. Starting with criminal jurisdiction, the Provincial Court is without question the province's primary criminal court. Provincial Court hears over 95% of all of the criminal cases that are heard in the province. The other provincial trial court, the Supreme Court, hears the remaining 5%. Now, there are a number of offenses under the Canadian Criminal Code that are reserved exclusively to the Supreme Court. And those include murder, and a few more exotic offenses such as treason, piracy, inciting mutiny. Similarly, there are certain comparatively less serious offenses over which the Provincial Court has exclusive jurisdiction. And then there is the vast majority of criminal offenses that lie in the middle, these are comparatively serious offenses over which the Supreme Court and the Provincial Court share jurisdiction. And with respect to those latter mentioned matters, the ones where jurisdiction is shared, a person who is charged with an offense of that nature has to make an election as to which court before which, the court before which he or she wishes to appear. The practical reality, though, is, as I've mentioned, the vast majority of criminal cases, that is to say 95% plus, are tried in provincial court, and that includes the serious cases where accused persons elect to be tried in the provincial court. Provincial court judges hear the criminal cases that come before them sitting alone. They don't sit with juries. Criminal trials with juries are only available for certain more serious offenses in any event, and those have to be heard by the Supreme Court. Moving on to family jurisdiction. Here again, the Provincial Court is the primary court for dealing with family disputes. It hears more than 80% of all of the cases in the family area in the province. And here again, jurisdiction is largely shared with the Supreme Court of British Columbia, the other trial court. Provincial court judges, like their Supreme Court counterparts, adjudicate disputes with respect to guardianship, parenting arrangements, financial child support, and financial spousal supports. Disputes over how the family property is to be divided, however, fall within the Supreme Court's exclusive jurisdiction. And I'll pause to say that as a provincial court judge, I was only too happy to leave that to the Supreme Court justices. The cases and the arguments over the division of property, while important, obviously, one might say have a less human dimension. And I found the family court work fascinating. And I felt privileged to be able to focus on the more human aspects of family law. And I say that with no disrespect to my colleagues in the Supreme Court, who have to worry about who gets the dishwasher and who gets the silverware. The granting of divorces is another family law domain, if you will, that falls exclusively within the Supreme Court's exclusive jurisdiction. The Provincial Court has exclusive jurisdiction over the whole subject of child protection. And provincial legislation in British Columbia provides a comprehensive statutory scheme governing that issue. That legislation defines the conditions under which provincial child welfare officials can intervene in the lives of children and families and exercise powers, including powers of removal, all with a view to ensuring that children are safe and that their physical and psychological needs are met. And leaving aside questions of appeal, the Provincial Court does all of that work in the province of BC. I move to the civil jurisdiction. Civil disputes, generally disputes over money, represent a comparatively small proportion of the Provincial Court's work. Whereas, by contrast, civil disputes represent by far the largest proportion of the caseload of the Supreme Court. However, the value of the civil disputes that can be heard in the Provincial Court must not at present exceed $35,000. That's a matter that's addressed by regulation, and there is reason to believe that monetary upper limit will rise to $50,000 in the near future. So, and there's also a bottom limit as well. Cases of a value of less than $5,000 are dealt with by an online tribunal. So the Provincial Court's jurisdiction regarding civil disputes deals with cases worth more than $5,000, but not more than $35,000. These are sometimes referred to as small claims matters, but I think most people would agree that while, of course, by comparison to the Supreme Court civil jurisdiction, where where they're sometimes dealing with multi-million-dollar civil disputes. For most people, I would say for most middle-class people, a dispute in the range of 25, 35,000 Canadian dollars would not be accurately described as a small claim. I'd pause here to say that while there is this limit on the value of the cases that the provincial court hears, there's no equation to be drawn between the legal complexity of a case and its monetary value. And indeed, sometimes the cases that come before us in the civil division in the provincial court have no shortage of legal complexity. Moreover, as judges, we are almost, not always, but more often than not, hearing those cases where the parties don't have counsel. And so that legal complexity comes before us, and we don't have the assistance of counsel to guide us through the law in that area. So the small claims or the civil jurisdiction is a comparatively small part of the work, but when one has to do that work, it is quite strikingly demanding at times. There are certain types of civil disputes that no courts have jurisdiction over in the province of British Columbia. They are relegated to specialized tribunals. Landlord-tenant disputes would be an example of that. Beyond those broad jurisdictional categories, the provincial court has developed a number of specialized courts. And it's done that in order to foster a more inclusive and effective approach to administering justice to vulnerable populations. I can't mention them all, but I will mention, make passing reference to a few of them. That we have what are called Indigenous courts. As an artifact of Canada's, excuse me, colonial history, Indigenous citizens of Canada have been chronically disadvantaged in numerous ways, and consequently they are vastly overrepresented in the criminal prosecutions and in the country's prison system. And so numerous initiatives have been pursued to attempt to redress those systemic disadvantages. The Indigenous courts are principally sentencing courts that operate in several communities in the province, and they give Indigenous offenders who have been convicted of offenses opportunities to be sentenced in ways that reflect the cultural practices of Indigenous First Nations, as we call them. They entail Indigenous community participation. Indigenous elders, for example, are involved in the sentencing processes. These are optional, but increasingly the option is being exercised by Indigenous offenders. There's a kind of opposite number to those in the family division called Indigenous Family Healing Court Conferences. Again, the same rationale lies behind them. We see many more children in the care of the state, so to speak, who come from Indigenous communities. This is again a legacy of Canada's colonial history. And so child protection and other family law problems, to the extent that they are amenable to mediation in cases involving Indigenous people, we see increasing interest on the part of Indigenous litigants to involve themselves in case conferences that incorporate Indigenous culture. We have a drug treatment court. We have domestic violence courts. Their functions are, I think, obvious just from the names they have. And if I had more time, I would talk more about them. These are what one might say are problem-solving courts, where generally it's again within the criminal division a type of process that comes in after a conviction has been entered or a plea has been given, and the focus shifts to the extent that an offender wishes it to, away from more typical punitive sanctions to more therapeutic and rehabilitative processes. So that's the the Provincial Court of British Columbia in a nutshell and how it fits into the broader context. I'm now going to say a few things about inclusivity and access to justice. I'm not here as a kind of public relations representative aiming to persuade you that the Provincial Court is doing a wonderful job in these areas. Like all courts across the common law world, meaningful progress has been made in recent years, but there's a great deal more to do, and I would say that is true for the Provincial Court of British Columbia just as it is for many others. Improving access to justice and inclusivity are always properly seen as works in progress, and we can't be complacent about the progress that has been made. It is important to acknowledge it, but it is important to recognize that there is still much more to do. And these subjects, I think, are perhaps more top of mind today than perhaps they've ever been, with all of the unrest that we see around the world, including in Canada and the UK, and certainly in Canada's neighbor to the south, having to do with the insidious effects of racism, for example, and the limitations that those attitudes have brought with them for the ability of citizens of various ethnicities to be able to take their proper place in society and enjoy the benefits equally of society. So improving inclusivity and access to justice are on the agenda for court systems across the common law world, and the challenges remain significant. I would say that members of our poorer members of our populations, and indeed even the middle class, unfortunately are quite commonly unable to vindicate their legal rights due to cost barriers. And certainly cost barriers are a feature or an aspect of access to justice that have to be confronted. It's especially true of the middle class. That sounds counterintuitive, but I would say that is so because members of the middle class frequently earn too little in the way of incomes to afford legal advice and representation from counsel, but they earn too much to qualify for state-funded legal aid. So reform initiatives have been underway over the past few decades to create the long-needed improvements in all of these areas, and it's no different in the Provincial Court of BC. There is much good work underway. There's a lot more to do. I'll start by talking about gender and ethnic diversity on the bench of the Provincial Court. Like Canada as a whole, British Columbia's society is a multicultural society comprised of substantial populations of ethnic minorities, in addition to its larger Caucasian citizenry. Indeed, British Columbia is Canada's most ethnically diverse province, with only 64% of its population having European origins. East Asians and Southeast Asians account for 18% of the BC population. Another 9.5% of the citizenry belong to South Asian and Middle Eastern communities. Indigenous British Columbians comprise almost 6% of the province's population. BC's Black population is for Canada comparatively small, coming in at under 1%. It is unarguable that in order to properly and effectively serve the population of the province, it is essential that the judges of the province's courts increasingly reflect the makeup of that population and its varying life experiences. And while there is a long way to go, the makeup of the Provincial Court increasingly does reflect the diversity in the composition of the province's population. To begin with gender diversity, 47.5% of full-time sitting Provincial Court judges at present are women, and 52.5% are men. And compared to the roughly 50-50 male-female breakdown of the population as a whole, that is a tolerably close approximation. And I can say that even over the time that I was sitting, 12 years, the gap, the gender gap, closed remarkably, and I'd say we were almost there. As to ethnic diversity, though, there's still a great deal more to do. Visible minorities collectively, including Indigenous peoples, comprise over 36% of the British Columbia population. But of the 122 current full-time sitting judges, only 18% belong to a visible minority. The largest representation comes from the South Asian, East and Southeast Asian and Indigenous communities, broadly reflecting the fact that these are the largest minority populations in the province. Some judges also belong to the LGBTQ community. The statistics regarding ethnic diversity and applications for appointment to the Provincial Court are, however, encouraging. They show that applicants are increasingly diverse ethnically, and so it is to be hoped that otherwise qualified and suitable candidates for appointment to the Provincial Court coming from a broad range of ethnic origins will enrich the court over the coming years and bring those statistics to the place where they should be, so that citizens in the province face a court that resembles the makeup, the ethnic and makeup and gender makeup of the population as a whole. There's also reason to be hopeful that we will see that outcome to be found in the statistics regarding enrollment in British Columbia's law schools. Those numbers are changing as well, and we are seeing increasing numbers of students being admitted and taking legal training. It will take some time for them to reach the point where they become part of the provincial judiciary, but these are works in progress, and the trends are, at least I can say, in the right direction. I move on to briefly discuss court interpreter services, because of course, being able to engage with the justice system in a language that you are capable using is fundamental to the ability to vindicate whatever rights you're seeking to vindicate before a court. Because of the rich ethnic diversity of BC's population, many of the parties who come before the court do not have English as their first language, and some of them don't speak English at all, or at least not with sufficient capability to be able to participate meaningfully in a court process. If their matters are adjudicated in the criminal, family, or child protection divisions of the provincial court, litigants who are not don't have a facility in English are entitled to provincially funded services of court interpreters at no cost to themselves. Because the nature of the rights being adjudicated in the civil division, essentially property rights, are different in kind from the rights that are at issue in the criminal and family and child protection areas, litigants in the civil division who require interpreters have to pay for them themselves. And I would say that I wouldn't be surprised if at some point a court challenge were to be mounted challenging that. It is true to say that there are meaningful differences between the rights at issue in a criminal case, a family case, a child protection case, than in a case between two businesses fighting over money. But on the other hand, when one thinks about the significance of a business dispute to a small business owner where livelihood may be at stake, it isn't a stretch, in my view, to view those rights as being so fundamental to the economic viability of the litigants that a case might be made that by denying state-funded or provincially funded court interpreter services, there may be some kind of violation of a fundamental right of freedom. I think we just have to watch to see if that will happen. But in the meantime, in the civil division, if you need an interpreter, you have to pay the interpreter. I'm going to talk a bit about legal aid and pro bono services. I'm going to have more to say about unrepresented litigants and the challenges they face in appearing before the courts and the challenges that they represent for the courts later. But before coming to that eventually, I will comment on some important ways that otherwise unrepresented litigants receive legal services, and in some cases, legal representation from qualified and capable counsel. BC's provincially funded legal aid system is widely respected, but also widely considered to be in need of greater funding and other improvements. This is a perpetual battle in Canada and in its provinces, and I know that is so in the UK and in other countries of the Commonwealth. No one would doubt that legal aid plays an essential role in ensuring access to justice for those unable to afford legal representation. And equally, no one would doubt that, and certainly judges wouldn't doubt, that having legal aid counsel it contributes enormously to the smooth running of proceedings that occur in the provincial court. Provincially funded legal aid is available to those with very low incomes, such low incomes that they're incapable of paying for legal advice and representation for themselves. It would take too much time to explain what legal aid lawyers do. They play crucially important roles in all kinds of areas. So I'm only going to hit on some of the highlights. Financially qualified persons charged with criminal offenses that could lead to sentences of incarceration are entitled to receive legal advice and representation at pretrial appearances and at their actual trials. Again, financially qualified persons, people whose incomes are low enough, who are charged with less serious offenses, can still receive that kind of representation if an adverse outcome could lead to the loss of employment or deportation. People who have physical or mental disabilities are entitled to legal aid on a more generous assessment. All youth, that is to say persons who are under 18 years, are entitled to legal aid in criminal proceedings, both as to advice and representation, both as regards pretrial appearances and trials. Family parties to family disputes can obtain legal advice and representation in certain situations, serious situations, such as when they need an immediate court order to ensure their safety or their own children's safety and security are preserved. When they need to address an issue involving a serious denial of parenting time or contact with their children. When a person who is of limited means faces an opposing party parent who threatens to remove children from the province permanently, then that can be challenged with the assistance of legal aid lawyers. Persons having guardianship or custody of their children who are encountering situations where the other family party is unlawfully withholding access or interfering with their ability to carry out their role as guardians can get legal assistance from the legal aid to bring those matters before the court and have them dealt with. Financially qualified parties to child protection proceedings, including situations involving removals of children from their families, are entitled to legal aid as of right. The Provincial Court, for obvious reasons, has a close working relationship with the provincially funded legal aid system. Legal aid lawyers play a crucial role in ensuring that unrepresented litigants who might otherwise flounder in their court appearances, being unfamiliar with the justice system, will have the benefit of skilled advice and or representation. But it is available to people who are very, very low on the income scale, and sadly there are many who are in need but don't qualify for legal aid, that fall between the stools, so to speak. Beyond provincially funded legal aid, there are some other pro bono organizations that provide limited similar services in the form of advice and representation to those who don't qualify for legal aid but are still of insufficient means to be able to retain and pay for counsel. These organizations are, they include charitable societies that have been created to offer pro bono legal services, and the services are often actually provided by lawyers who volunteer as part of their giving back to the community, so to speak. Also, the law schools in the province have programs that make law students under supervision available to provide legal aid-like services to some people. I move on to user-friendly resources. Because it handles 95% of all criminal cases and 80% of all family cases in the province, the Provincial Court also sees the largest number of self-represented litigants in the province, of any court in the province. Self-represented litigants are growing in their presence in all courts, and in the Supreme Court of British Columbia and the Court of Appeal of British Columbia, people are coming more and more often before those courts, attempting to do the complex work that's to be done without counsel. That I think is true in the UK and elsewhere as well. It is just a fact of modern life that the cost of legal representation and legal advice has increasingly overtaken people's ability to pay, and they find themselves having to go before courts and tribunals without counsel. But the Provincial Court, given the nature of its caseload, the vast majority of family and criminal cases, sees more of that than any other. Because the monetary limit of the civil jurisdiction in the Provincial Court is $35,000, as I explained, dollars, self-represented litigants are the vast majority in the civil division. Many of those self-represented litigants who come before the Provincial Court earn incomes that are by no means high, but are nevertheless too high to entitle them to legal aid. And so these litigants must seek to navigate the court processes they engage in with either very little or no legal advice or representation. And the Provincial Court has from early days consciously endeavored to use a plain language approach in crafting its rules and court forms, for example, recognizing that many of the people who appear before it will have little or no assistance in making those rules and forms intelligible. So the Provincial Court small claims rules, for example, were one of the first full-scale examples of a plain language rewrite of court rules with a view to making them intelligible to ordinary people. Similarly, we all see in our societies an increasing emphasis on electronic means of accessing court processes, but it's recognized in the Provincial Court that by reason of computer literacy issues, for example, that having an exclusive or predominantly electronic interface with the public, the Provincial Court would effectively raise barriers to justice that would be insurmountable for many of those it serves. And so paper filings alongside electronic ones continue together to ensure that no litigants are prevented from accessing justice by reason of the fact that they don't have the hardware or the computer savvy to be able to deal with the court in that way. The court publishes both online and in paper form many resource materials aimed at explaining court processes and helping litigants without counsel to know what to expect and how to prepare for the court appearances. And I'll pause here to say, I provided Aldo with a list of links and a few cases that speak to the various issues I'm addressing in this webinar that he will then distribute to those who would like them. These are hyperlinks that will take you to examples of what I'm describing. There are, I've just been talking about legal aid. There are reports about legal aid, things that explain how legal aid works in the province. These how-to resource materials I've just mentioned for self-represented litigants, there are links to those. So you can see all of this material and have a look at it with more time once we've concluded today. I'm going to say a few things about public outreach. The Provincial Court is, and I think this is a good thing, engaged in active public outreach, all with a view to receiving candid feedback from those it serves that can be used to improve its processes and ultimately thereby improve access to justice. For example, the court now has a retired judge serving as the court's digital communications coordinator. That retired judge has created many portals on the Provincial Court website to assist anyone requiring information about the court and its processes. These resources in most cases are replicated in paper form and can be accessed and obtained from court registries across the province. The digital communications coordinator also writes and publishes regular e-news items to which many subscribe and which contain news and information of practical benefit to those who come before the court. And you'll not be surprised to know that most recently the emphasis in those has been on how the court has been adapting to the COVID-19 pandemic and how court processes have been adjusted to take account of the need to temporarily suspend in-person hearings. All of the written decisions given by provincial court judges in the criminal, family, child protection, and civil cases they hear are published in a searchable database that is accessible free of charge on the court's website. And so that's a database that's a valuable tool for litigants and their counsel, if they have counsel, who wish to research the law that is developed surrounding particular issues, the law that is developed within the provincial court jurisprudence itself. The provincial court website, and I think this is very important, also provides a comprehensive and fully articulated outline and how-to guide for recourse by anyone who may be aggrieved about how he or she was treated when dealt with by the court. And that includes by judges. That portal on the website explains to people how they can file complaints about what they perceive to be judicial misconduct and how those complaints are processed. And again, I say much of the informational content displayed on the website is available in paper form, recognizing that a goodly number of people who deal with the court may not have the computer resources to get it online. The provincial court's current chief judge, together with her associate chief judges, carries on a long tradition now in the provincial court of having face-to-face information sessions with the public. At those sessions, updates are given to members of the public about various court initiatives, and members of the public are given an opportunity to ask questions and express their views. And I can say that sometimes the feedback provided to the chief and her associate chiefs can be spirited and sometimes hard-hitting. It's not always a comfortable experience, but the practice continues, and I think it's a worthy and worthwhile practice. This is all about transparency and engagement. We can't improve if we don't know what people if we don't hear what people think calls for improvement. Those perspectives are not always balanced and helpful, but often they are. It's very important for the court to remain in touch with the community it serves. And so this public outreach will continue, and it has from time to time yielded changes in policy and practice that might not have otherwise come. More recently, these in-person group sessions, public outreach sessions, have been supplemented by something called Twitter town halls, conducted on Twitter, where participants can pose their questions and get their and offer their suggestions electronically, and the chief and the associate chiefs can then respond. I'll leave that subject and turn now to judicial mediation. Access to justice carries many connotations, and one of them relates to the manner and speed with which parties' disputes are brought to a conclusion. The issue of how the court experience might contribute to the way that the parties deal with disagreements in the future is clearly an access to justice issue. And I'm going to focus now mainly on family cases and to a lesser degree on civil disputes, because these are the areas, the family division, the child protection division, and the civil division, where the court provides judicial mediation. Indeed, it doesn't just provide it, these are mandatory steps in the process. Judicial mediation means mediation where judges play a different role. They're not playing an adjudicative role, they're playing a mediator's role. They are facilitating progress toward consensual resolution and disposition of disputes. Judges, obviously, who are assigned parties to a proceeding for mediation, where they take over, where they perform the role of mediation, cannot sit as trial judges on those specific matters if the mediation doesn't yield a settlement. It's obvious that being privy to the negotiations that go on in a mediation, it wouldn't be appropriate for the same person to then shed the judicial mediator's role and then step in as a trial judge. So if you, as a provincial court judge, preside over a mediation in a family case, a child protection case, or a civil case, then if it doesn't resolve, it will be a different judge who will take the trial. I say participation in judicial mediation is mandatory. Obviously, reaching agreement isn't mandatory. You can't force people to come to a consensus, but you can require them to participate. And that is what is required. And I can say that judicial mediation is one of the most successful innovations that the court has undertaken over the years, over the last several years. Judicial mediation produces very high rates of resolution in the civil division and tolerably high rates of resolution, at least of some issues, in the family and child protection divisions. It is an enormous service to those litigants to provide them with this off-ramp, so to speak, and give them the opportunity to bring their disputes in whole or in part to a consensual outcome. One of the things that I think anyone who works with and around justice systems knows and understands, especially in the family and civil areas, is that an unintended consequence, but an unavoidable consequence of engagement with the adversarial processes of the court system is that differences are emphasized, divisions are deepened, conflict is inflamed. After all, the courtroom at the end of the day is a civilized battlefield, and X is seeking to conquer Y, and Y is seeking to conquer X. And so all of the skills that one develops to be successful in a trial or a hearing are skills that are skills that are rather ill-suited to what lies in the future once the case is over and the outcome has been determined. In family cases, and often in civil cases where you might have a dispute between a business and a supplier or whatever, there are ongoing and long-term relationships that have to be in some fashion preserved if if those relationships are disrupted unduly by the process of becoming involved in the court system, then the legacy of the involvement in the court system, while it may include a judicial determination, it may leave lasting harm to the ability of the parties to work together. And this is more obvious in family cases than anywhere else. So when one thinks of the skills you develop as a litigant in a trial or a hearing, it's to the skills are all aimed at conquest, so to speak. Whereas in mediation, the skills that you are developing with the judge's encouragement and assistance are skills that will aid the participants in the future if they can take what they learn from the experience and use them in the future. And one of the benefits of judicial mediation is that not only does it get people out of the revolving door kind of relationship that they can sometimes have with every problem that comes up requiring another court appearance, it can assist them in having and developing the skills that they can use then without the judicial oversight and judicial facilitation, and bring them to the point where they don't have to return to court over and over again. And the experience isn't as traumatic, isn't as harmful to their ability to work with each other. Two parties who now live in separate households but who have children in common have a undeniable need to be able to deal with each other. If the children are moving back and forth between two households, there are many issues that are going to have to be confronted from time to time. And if the atmosphere between the parties has been inflamed by hearing, and sometimes that's unavoidable if it can't be settled, but it's a whole lot more difficult going forward than it ought to be. And those who resolve their disputes with mediation find themselves being able to draw upon the skills that they learned in the mediation, skills of thoughtful and careful weighing of their respective positions, a willingness to show some flexibility, compromise, finding common ground. All of that can be very useful going forward. Enough about judicial mediation. I'm going to close with just a few words about rendering assistance, judges giving assistance to self-represented litigants. We find them before us all the time. Often, and I'm going to really go quickly through here because I know we have not too much time left for questions. The law has developed such that judges who preside over cases where self-represented litigants are appearing have an obligation to lend a certain amount of assistance so that in a criminal case, for example, a person's defense, because it's obviously going to be the accused who is without representation, there's always a lawyer on the Crown side, the accused must have the opportunity to present whatever defenses are there and must otherwise engage in a trial process that is fair. This entails a certain amount of judicious entering the fray, so to speak, on the part of the judge, rendering enough assistance to protect trial fairness for the self-represented party without sacrificing impartiality and losing the independent, impartial role that comes with being a judge. These are things that are very challenging, especially in family and civil cases where often both sides are unrepresented. The assistance that you render to one party may be perceived by the other party as a sort of an abdication of your impartial function. You can intervene, you must intervene sufficiently to protect fairness, but not so much as to give an appearance of having lost, having taken aside and given up your independent, impartial responsibility to hear the case in a manner that's fair to both parties. This is a very compressed summary. The materials that I've given to Aldo that he's going to distribute to you later include some cases that talk about the principles that guide that particular aspect. I can say that appellate authorities that talk about this, because this comes up on appeal. You're going to see this in appeal where someone appeals a decision in the provincial court saying, a criminal accused might say, there was a conviction and the trial judge didn't explain to me some of the things that I needed to know in order to be able to properly defend myself. Or in a civil case, a family case, there's an allegation that the judge went too far in helping one of the parties. Those things come before the Court of Appeal or the Supreme Court if it's in an appellate role. And the courts make some broad statements of policy and principle about the importance of going far enough but not too far. But the challenges in the moment are enormous, and I can say that from personal experience. I can articulate and understand the principles as well as anyone, but moment to moment in a long family trial where you have two parties unrepresented and who are floundering, and you are wanting to render sufficient assistance to ensure that they have a fair trial without going too far, I can tell you is one of the most challenging aspects of the work. So I think I've said enough, and I'm probably spent too much time on this part of it. I would be happy to take questions and sort of move to that phase of things, and subject to your timetable and your availability, I'll certainly not be strict in terms of my approach to the hour that we've been given, because I've taken too much of it with my own words.
Thank you. Thank you very much, Tom. That was extremely interesting, I'd say, and drawing on your own experience and your own insights, I think we all found it extremely interesting. So we'll open the floor up for questions. Given the time, we'll perhaps take a round of questions now, and then if there's still some time, we might take one or two after that. But if anyone wants to ask anything, now is the time to register your interest. I see Rohan has his hand up. Rohan.
Thank you very much, Aldo. Thank you, Judge Woods. That was really an inspiring discussion there, and it's so interesting to see from your exposure to the provincial courts just to what extent diversity and inclusion is important for you as a judge personally, and I really appreciate listening to that, so thank you for that. My question really, I have two small questions that you may not consider small, but I have two questions. The first is, you touched on the issue of impartiality for a judge, particularly when dealing with litigants in person, we call them here in the UK, but you may refer to them as unrepresented parties. But to what extent have you been able to deal with unconscious bias? And that's a personal question to you as a judge, not the kind of standard response that we would expect from the judiciary, but from your experience now as a retired judge, perhaps you can speak with a little bit of freedom on this point. But to what extent have you grappled with the issue of unconscious bias in the cases that you have addressed over the years? And the second question really is, to what extent, I mean, you talked, for example, about the increased representation of minorities coming through the judicial system, and that there are more applicants from minorities applying for judicial posts. But to what extent do you think is it made more challenging that judicial selection panels may not necessarily represent a high level of diversity? and that for applicants that lack judicial skills simply because maybe of a lack of opportunity in terms of their work as barristers, that they have the necessary skill set to apply as judge for judicial posts in the first place? Those are the two questions.
All right, thank you. Those are both good questions. Let me start with unconscious bias. Unconscious bias is a phenomenon that I think fair-minded people are prepared to admit exists in the human species. It would be unhelpful and also, I think, intellectually dishonest to simply deny that there is such a phenomenon. By its nature, unconscious bias lies below the level of consciousness in many respects, but I think we can sensitize ourselves to the prospect that there may be unconscious bias and become more vigilant for it, and thereby control it and remove it from any sort of decision-making equation that we may be seeking to solve. Unconscious bias exists in ordinary human dealings. Judges are trained and expected to exclude unconscious bias from their decision-making, to be watchful for its incipient appearance, and to manage it, to remove it from any decision-making exercise that might be undertaken. So, I mean, this is the very heart and core of a judge's role, is to come with a clean slate in terms of attitudes and so forth to a case, to allow the evidence and the applicable law and nothing more to bear upon the outcome, and to not permit biases of any kind to guide or shape the decision. This is what I'm describing is an ideal, and judges being human, judges will not always achieve the ideal. They will approximate the ideal. I think it's all we can expect is, firstly, that judges come to the bench with a strong and resolute commitment to even-handedness, fair-mindedness, determination to not allow anything other than the evidence and the applicable law to guide their decision-making, and to be ever vigilant for the insidious effects of unconscious bias. As to minorities and their increasing representation, or what we anticipate and hope and endeavor to see, their increasing representation on courts all around the world. The appointment process in British Columbia involves, I can't explain it in its entirety, but I can say that we are seeing more diversity in judicial appointments, I believe in part because those who are involved in the appointment process also reflect that diversity. There's something called the Judicial Council that takes primary responsibility for recommending candidates for appointment. Ultimately, it's the Attorney General of the province of British Columbia who makes the decision from a list of those who have been recommended by Judicial Council. Judicial Council processes the applications. Those who are shortlisted are given an interview, and then depending on the performance in the interview, the candidates are either recommended or not. And it takes 2 dissenting votes only on the Judicial Council interview panel to take a candidate out of the running. Those panels are ethnically diverse. Those panels convene to have an interview with the candidates and they have before them the application and the fact-gathering work product that precedes the interview, where persons who are candidates, their contacts in the community, and it's not just the people they give as references, but others, you know, lawyers who have been on the other side of cases of a candidate, for example, they will all, there will be interviews and telephone calls made to confidentially determine what kind of reputation the candidate has in the community. And I would say that at all levels, including the population of those who sit around that horseshoe-shaped table when you go for the interview, reveal diversity of the kind that is desirable. And so I would say that all of that feeds into the ultimate decision-making as to who gets appointed. Sadly, you know, economic and other disadvantages associated with race and other factors have meant that, for example, there have been fewer Indigenous Canadians getting the kind of education that in turn enables law school doors to open to them, which in turn allows them to enter practice and ultimately build the kind of repertoire of skills and experience that creates the opportunity for judicial appointment. And those systemic factors take a long time to change. We do see them changing. We don't see them changing as quickly as we would like, but I would say that the trends are in the right direction, and as difficult as it must be, as it is, we must be somewhat patient while always pressing for accelerated gains in those areas. I hope that's a responsive answer.
Thank you very much, Judge Woods. That was excellent. I would think that perhaps the progress in Canada is slightly more progressive than here in the UK, but thank you very much.
Thank you.
We have hit time. But I'll take you on your very generous offer of perhaps answering one further question, and then we will. And this relates to litigants in person or unrepresented litigants, to which you alluded at various stages in the presentation, and particularly towards the end. And it's effectively maybe from your own experience, whether you have encountered particular significant issues, challenges that you know, unrepresented litigants may present the court system and the court process.
Well, yes. Self-represented litigants or unrepresented litigants are immensely challenging. The legal processes that over which we preside are unavoidably complex, and I've referred to initiatives that have been undertaken to try to make them as quote-unquote user-friendly as possible, but there's no way to make the complexity of a criminal trial, for example, to reduce it to the point where someone who has no legal training and hasn't really devoted much, if any, time or effort to preparation, to make it even slightly intelligible. So it's not uncommon, not at all uncommon, to have an unrepresented accused in a criminal proceeding where the issues are serious, but the person's income circumstances preclude recourse to legal aid. So this person is standing before you answering a serious charge without counsel, and really hasn't got a clue as to how to conduct his or her defense. In a case like that, you begin by taking time to provide a broad outline of what the trial process looks like, about where the obligations lie, about what choices the individual has to make at various points along the way, about what the burden of proof is on the Crown, about the about the fact that whether the defense calls any evidence is a decision that should be made carefully at the end of the Crown's case, and that it's not necessarily an automatic decision to call evidence for the defense, about what a direct examination is like, about what leading questions are and why you can't ask them in a direct examination, about how to cross-examine. These are all complex things. And every judge, me included, provides a kind of primer on all of that subject matter at the beginning of a trial, in the hope that some of it will provide some assistance. But inevitably, there are going to be times when you have to intervene and steer someone back to where they should be when they lose sight of what they've learned. And sometimes an accused in those circumstances will become exasperated and frustrated, and you will have outbursts and so forth. All that can be done, as the law tells us, is that you have to make a reasonable effort to ensure that at the end of the day, the trial is fair. And if the self-represented litigant undermines his own or her own position through intransigent refusal to do what the process calls for and so on, beyond a certain point, you will have done all you can, and matters will fall where they fall. But you know, judges speaking colloquially with each other will sometimes bemoan the prospect of yet another case involving self-represented parties. I'm speaking somewhat candidly now. But there's another way to look at it, and that is that self-represented parties are here to stay for the time being. We have every bit as much of a responsibility to see them through the process as those with counsel. It certainly makes our job more difficult, but it's also a challenge, and frankly, it's very satisfying when you can take someone who is floundering, have meaningful engagement with them in terms of trying to give instruction as to how to proceed, and cultivate a willingness to listen, a willingness to kind of keep the lid on in terms of the emotions, and actually produce results so that they actually do a creditable job on their own behalf as a result, at least in part of the urgings that you give. And I'm not trying to paint myself in a particularly positive light, but I certainly try to confront every case involving self-represented litigants, and I had many, many of them, as opportunities that that I could, within the bounds of what the law permits, lend the assistance to ensure that this process was ultimately fair. It's not the same as stepping down and becoming a lawyer for the self-represented litigant. That's the sort of thing that gets judges in trouble, but it's equally a risk to not do enough. And finding that middle ground where you're doing enough to preserve fairness, but not too much to sacrifice impartiality, and becoming an advocate is the elusive and challenging aspect. But I think I won't pretend that there weren't times when I wasn't exasperated by self-represented litigants, but I also can say that I have many recollections of feeling great satisfaction in having been able to get someone settled and calm, and doing as best as a layperson could do with by taking up some suggestions and learning something from what I offered in the way of guidance.
Judge Thomas, can I, sorry, Aldo, just very quickly ask a question on this? I'm very mindful of time, but have you ever been appealed, Judge Woods, by the represented party on the other side, in terms of perhaps the issue of impartiality, in terms of helping the litigant in kind too much? Has that ever happened to you?
I'm I'm happy to say that no, I haven't been. But I am also modest enough to say that I can well imagine that that could happen at some point. I'm not sitting any longer, so I guess it couldn't happen. But appeals like that are brought and are successful sometimes, and I don't pretend that I couldn't have slipped into error in that way, the way some of my colleagues have, and the cases that provide us with the guidance are premised on circumstances where someone made errors, appealable errors in that area, and I'm grateful not to have been appealed very many times for any reasons, but I have made my mistakes and I have been appealed and successfully so before, and that's the kind of mistake that I couldn't stand before you and tell you that couldn't happen with me, but thankfully it didn't happen with me.
Thank you very much, Judge Woods. Perhaps we can expect a future guide on avoiding appeal in the future with litigants in person, but thank you very much.
Great.
Thank you. And with that, I think we'll bring proceedings to a close. It's been, I'm sure all participants would agree, a really informative and interesting discussion and presentation, and thank you very, very much. And thank you also very much for the additional material that you have provided, and I will send this by email to all those who have registered for the presentation today. But thank you wholeheartedly for a really interesting presentation.
Thank you, Aldo, and thank you to all the participants. I have enjoyed this opportunity to speak with you. I found the questions that were posed at the end well thought out and interesting, and to some extent challenging. Always a good thing. It's a great pleasure and privilege. I wish I could be doing this in person. I would love to be in Cambridge, although there's nothing too much wrong with Vancouver, but this has been a great experience for me, and I thank you for your attention today.
Thank you. Thank you.
Thank you very much. Thank you.
Thank you. All the best.